Hello everybody, it's Rick. It's August, Sunday, it's the 16th, 2026. So today's video, we're going to talk about how I successfully vacated a California subscriber's 2018 support order and $30,000 in arrears through a personally prepared motion and coaching courtroom behavior. You see the thumbnail. This is the email I received after I asked what happened. Anyway, so let's go through it. But before we do that, let's talk about if you're interested in my affidavits or my coaching by phone consultation to have support set aside, stay off support. It's you can do that. You can contact me through my email addresses below. Always check your spam folders. Okay, so what happened was back in, not this, click on the wrong thing, of course. I received an email. As you can see here, this is an email exchange back on June 25th. And what usually happens is when people reach out to me, I try to ask a few questions to see if I can help them. I don't want anybody sending me a gift for paperwork unless I feel I can help. Okay, I'm not looking to take anybody's money unless I can help them. That's why I'm having more success personally dealing with people. Excuse my voice. Anyway, so what happened was he was never served or signed any contract. He just started receiving monthly payments in the mail. And recently they just started, they summoned him for court on the 27th of July. Anyway, what happened was he was never contacted, and this is back in 2018. So this is a pretty regular practice by them. What they do is they'll mail it to your house and to tell you to show up. And the process is if they mail it to you, they assume you received it. Okay. So whether it's lost in the mail or you don't take it serious, but once you don't show up, you defaulted, and then everything that they're making claims for stands as truth. Okay? So the best thing to do is if you receive a letter in the mail is to respond. Okay? In writing. Okay? Do not give them all the information they're looking for. They're always asking for your financial information, things like that. Don't give them any personal information. What you should do if you receive something in the mail is reach out to me. Those are the best cases for me. Anyway, so this case started in 2018. All right, so he said he never received it, and they're claiming he owed $30,000 in arrears, and they had a support order for X amount of dollars a month. Okay, so they're looking to. They started a court case, the agency. Okay, I'm going to do a video on these agencies because when you go to one of these agency hearings, they're allowed to use hearsay. And hearsay is not admissible evidence. Okay, but then they take the inadmissible evidence and then they bring it into the courtroom, and then it becomes admissible if you're not there to challenge it or you don't know how to challenge it. I know how to challenge it. Okay, so that's how it becomes fact. Hearsay becomes fact. Hearsay is not a fact. Hearsay is inadmissible. Anyway, so let's frame what happened. I told you that the 2018 support order resulting in arrears. So what happened was, when he didn't receive 2018, what happened? He was denied due process. Due process, one of the due processes is you have the right to defend yourself. You have a right to be heard. He was denied this right. And that's one of the things we addressed. Okay? So, you could read this. Then I just put that, I just said that. And if you don't receive notice, it's an excusable default. Remember I said they can file a default against you. The order becomes a default because you weren't there to defend yourself. But if you weren't notified, it's an excusable default. So you have an excuse. So how many of you out there weren't notified? Or you can prove you weren't notified. Okay, then you can have the arrears set aside. All right. So on March 27, 2018, that's when the order was entered because he wasn't there. All right, he didn't receive any personal service where they hand it to you, or mailed when you receive it in the mail. Okay, he argued the delayed awareness prevented a timely response. He could not respond in the statutorily required 30 days. And, well, if you, again, and that's what's called an objection. I like to use non-statutory objections because there's no timeline. But he wasn't notified, so he couldn't make a timely response. All right, so service and notice is being challenged. So the affidavit asserts, and this is a summary. These slides that I'm showing you, these summaries are based on the motion that I personally wrote for him. I prefer these days to personally write the paperwork for you because you have a better chance of winning, because I could add personal details in there and I could fight it better. If you feel like you want that, you reach out to me. Okay? So, anyway, here's the opportunity to be heard. It is an essential requirement of due process of law in judicial proceedings. An opportunity for a hearing before a competent and impartial tribunal. So if you're in one of these statutory tribunals that were created solely for the establishment of paternity, establishment of support, or to enforce a support order that was created in one of these agency hearings using inadmissible evidence, it's not really impartial because their sole purpose was created for this purpose. You want an impartial fact finder. You know what a fact finder is also? Is a witness, because they're the witness, the evidence. But they're not impartial if their sole purpose is to establish, they were statutorily created to establish paternity, support, and enforce support. And the state receives financial incentives. So they're not unbiased. They're not impartial. Okay? So again, due process requires that a person have a fair chance to respond to the allegations made against him or her, and that opportunity must be provided in a reliable and orderly fashion. This is constitutional law. It's American jurisprudence. These quotations, they're based on previous court hearings. I like to use previous court adjudications. They're very effective. Okay, so the relief theory. The affiant frames the order is voidable due to an excusable default. That's what I said before. So, this is from California jurisprudence. Okay, this is the code here that we used. Even though it's not effective until January 1st, it's already been accepted by the legislature. It's been ratified. So we used it. Okay, read it. And again, this is for California. All right, so what we did was we said also you got to be careful when you go to these hearings. They might use these hearings as a way to trap you into giving them jurisdiction by waiving personal jurisdiction. You unknowingly waiving. Even though you can only waive something intentionally, you can unknowingly do it. So what we always do, what I do is I make sure that I have a little thing in there about personal jurisdiction. Okay, and appearances have been classified as either general or special. An appearance is special when the defendant appears for the purpose of objecting to the jurisdiction of the court over the defendant's person. Now, in the past, I've told you what a person is. A person is a mask. There are different persons, legal entities, and they're telling you right there. And I've used this before in my past videos. Okay, so and again, it's past court cases. They've said that jurisdiction must affirmatively appear in the record. Now, one way they get around it, the fact finder, the judge, will say, "Oh, we have personal jurisdiction." And to them, they're just asserting it verbally. We want it in writing, okay? Always want things in writing, because it's just words. How are you going to prove it? All right, I did that already. You can also, in California, you can object to these commissioners. All right, they're not judges. They're just there, again, they're not an impartial adjudicator. So you have the right to object, and this is under California jurisprudence. This is from the courts, powers and duties of court commissioners. Okay, these are the duties that they've been prescribed. Okay, and you have the right to object. So read this. Pleading sufficiency. That's what we challenged. Because a lot of these, the paperwork you receive from them, it's just very generic, boilerplate. Okay, and they're allowed to be liberally construed. That's the excuse me. Sorry, terminology. So we challenge that. Okay? And you want to challenge these early on in the case. You don't want to be a surety. You enter into a suretyship where you're going to enter into a contract to assume the debt. Okay? And then you cannot enter into a suretyship through implication, meaning it implied. You have to expressly enter into this suretyship. It's another form of a contract. We won't spend too much time on it. Okay? In California and everywhere, you're allowed to tell them they don't have a right to use your private data. Okay? So the strongest review issues are service, notice, jurisdiction, and the adjudicator authority. We objected to that. We objected that you never received service and notice, and we objected to personal jurisdiction. Standing and pleading arguments may require closer scrutiny of original pleadings. There's, if any of you have been doing this a while, or, the video out there, the sufficiency of pleadings. Okay? Again, the suretyship is something I throw in there. I also throw in there, you don't want to establish an agency relationship. Okay? So anyway, as you saw in the thumbnail, maybe I didn't show it. The judge gaslit me. So the judge didn't want to make any statements on the record, but only what he did do was he set the order to 0, and then he said it's all for your case today. Okay? Another thing that I do is I tell you, if you're there to file a motion, you're in a tricky situation because you're there as a movant. Okay? So you have to cooperate, but they're going to try and trick you. So you're going to try to, that's why the whole personal jurisdiction thing, making a special appearance is put in there. Okay? So again, $30,000 and the order for monthly support is now 0. Okay? Vacated. Set aside. Success. Okay? So this is just to show you guys that these things work if you know what you're doing, if you know how to challenge due process, sufficiency of pleadings, you're not submitting to personal jurisdiction. Basically what you're showing is you have a clue on what you're doing. So reach out to me, okay, if you're interested in receiving help. Okay, I make no guarantees, but I made no guarantees to Mike, and he has no more $30,000 in arrears that they set because he didn't show up because they never notified him. Okay? All right. I'll talk to you guys soon. Bye.